Welcome to Concerned Citizens Presents. Concerned Citizens of Laguna Woods is an organization dedicated to peace, economic and social justice, good government, and a clean environment. Every month, we invite an expert to enlighten us on a topic related to our mission. Because Village TV videotapes these presentations, we can share that expertise with a larger audience. We hope you enjoy today's broadcast.
Good evening, and welcome to Concerned Citizens Tuesday night program in Clubhouse 7. I'm going to pass the microphone to Jonathan Adler, who is our parliamentarian extraordinaire, to introduce our speaker. Let's give Jonathan a hand.
Sure. Concerned Citizens is proud to present a talk that our speaker titled "The Erosion of Science and Secularism by an Increasingly Right-Wing Court." Eddie Tabash is a constitutional lawyer, expert on religion cases. He was on the board of trustees of Americans United for Separation of Church and State for 27 years, and he now chairs the board of directors of the Center for Inquiry, a secular humanist and scientific skeptic organization. He is very experienced in defending the constitutionally mandated principle of government neutrality between belief and non-belief, and in opposing attempts by any branch of government to provide special privileges for only those who claim a religious affiliation. Mr. Tabash has filed many briefs in the U.S. and California Supreme Courts and in the federal and state courts of appeals. He earned his B.A. magna cum laude from UCLA and his J.D. from Loyola Law School. So please hold any questions until after his talk. The floor is yours, Eddie.
Thank you for inviting me to give this presentation that I hoped I'd never have to give, because this is a presentation about the takeover of the United States Supreme Court by the religious right, and it's a presentation also about a new looming threat to the Constitution that very few people know about, but is something we have to stop. Since the 1980 presidential elections, I've been warning about a religious right-wing takeover of the Supreme Court. For the first time ever, that occurred in October of 2018 when Trump's nominee Brett Kavanaugh replaced Anthony Kennedy. The majority of the religious right was then expanded to a supermajority of 2/3 2 years later, when Trump managed to confirm Amy Coney Barrett to replace Ruth Bader Ginsburg right just before Trump lost his bid for re-election. Now, what do we mean by separation of church and state? The first thing I need to say is that my presentation this evening discussing the importance of preserving equal rights for both believers and non-believers. This presentation means just that. It is not to denigrate religious people. It's only to make sure that no one has greater legal privilege in the United States because their viewpoint on matters of religion, whatever that is. So this is an argument for the equality of everyone before the law, irrespective of how they view the nature of reality in terms of religious belief systems. Now, there's a remarkable history that demonstrates that the framers intentionally created the religion clauses of the First Amendment in order to secure the equality of believers and non-believers before the law. We don't have time this evening to review this record. However, it does justify the definition of separation of church and state that we will be using. For our present purposes, we begin with the 1947 Supreme Court case of Everson versus Board of Education, where it says the establishment of religion clause of the First Amendment means at least this: neither a state nor the federal government can set up a church, neither can pass laws which aid one religion, aid all religions, or prefer one religion over another. Neither can force nor influence a person to go or to remain away from a house of worship against the will of that person, or force somebody to profess belief or disbelief in any religion. No person can be punished for entertaining or professing religious beliefs or disbeliefs, for house of worship attendance or non-attendance. No tax in any amount, large or small, can be levied to support any religious activities or institutions, whatever they may be called or whatever form they may adopt, to teach or practice religion. A further elaboration of this was in 1961 in the case of Torcaso versus Watkins. The Supreme Court said, "We repeat and again reaffirm that neither a state nor the federal government can constitutionally force a person to profess a belief or disbelief in any religion, and that no branch of government can constitutionally pass laws or impose requirements which aid all religions as against non-believers." One of the most important formulations of this concept was enunciated by the then majority in the 2005 case of McCreary County versus ACLU. The court reiterated its long-standing decree that no branch of government can favor religion over irreligion. That's its exact words. It is this phrase, so crucial to the equality of everyone, that is now ominously in grave danger. The current religious rights supermajority is posing a serious threat to the very survival of government neutrality in matters of religion and to the equality of believers and non-believers before the law. Here are some of the major decisions the court has used to begin to impose actual theocratic oppression on us ever since the religious right first achieved its initial 5 and now 6-vote majority on the 9-member court. The court is using 2 approaches. One is to allow all branches of government to show favoritism for belief over non-belief. The other is to carve out special rights for only religious objectors to avoid complying with laws that are otherwise binding on everyone else. In 2019, in American Legion versus American Humanist Association, the court ruled that a Latin cross placed on public property in Maryland in 1918 to commemorate local members of the armed forces who died in World War I was constitutionally permissible. This was based on an assertion that over time, otherwise religious symbols can become embedded features of a community's landscape and identity. They claim the community may come to value them without necessarily embracing their religious roots. This is pure subterfuge. Latin crosses haven't lost their religious meaning over time and somehow morphed into secular symbols. It's for private individuals who choose to have such crosses on their property or on their grave sites, but it's not for government to impose or to erect any religious symbol. In 2020, in Espinoza versus Montana Department of Revenue, overturning decades of precedent, the court held that if a state decides to create a private school voucher program, it must fund private religious schools along with private secular schools. The court had never before held that states are required to fund religious institutions when they fund secular institutions if the money might be used for religious proselytizing purposes. In fact, the court had previously held that the Constitution does not even permit, much less require, public funds to go to religious schools in those circumstances. Justice Breyer, in his dissent, pointed out that taxpayer money should not be used for the inculcation of religious beliefs, which is what private religious schools do. Otherwise, taxpayers are being forced to fund the propagation of viewpoints on matters of religion with which they disagree. The case of Our Lady of Guadalupe School versus Morrissey Beru. The court rejected federal employment discrimination claims brought by 2 elementary school teachers at Catholic schools. The court ruled that religious institutions are exempt from complying with the nation's employment and discrimination laws. The court allowed a Catholic school to terminate a teacher just because she came down with breast cancer. No other type of employer could get away with this. Religious institutions can avoid complying with all employment and anti-discrimination laws when it comes to those it hires to proselytize the faith. This is called the ministerial exception. Now, the court extended this to cover all employees, even those whose jobs don't involve clergy-type spreading of the religion, so that religious institutions stand alone as the only type of employers in the country that can freely discriminate against any employee without having to worry about employment and anti-discrimination laws. In Roman Catholic Diocese of Brooklyn versus Cuomo, the court struck down the New York governor's COVID-related restrictions on the number of people who can gather for worship services based on the court's defective interpretation of what the free exercise of religion should mean. In dissent, Justice Breyer pointed out that the rules established for religious organizations are applied to similar meetings in public lectures, concerts, and theatrical performances, whereas in places of worship, people were much more likely to be gathered together more closely for longer periods of time. It was a 5-4 decision favoring special rights for only the religious. Had Ginsburg still been alive, the case would have gone the other way. Her replacement, Trump-appointed Barrett, was sworn in on October 27th, and this case was decided on November 25th, less than a month later. This was one of those rare cases where we got Chief Justice Roberts on our side, but still lost because of the new religious rights supermajority on the court. In 2021, South Bay United Pentecostal Church versus Newsom. Here, the 6-3 religious right majority voted to strike down a number of COVID-related restrictions that California had in place regarding indoor religious services. There were only 3 justices on the church-state separation side, Breyer, Kagan, and Sotomayor. Kagan wrote a powerful dissent, joined by the other 2. She pointed out that California did not single out religious gatherings for any fewer rights. The state grouped together political meetings, attendance at lectures, movies, plays, concerts, and the hospitality industry. There was no singling religion out for invidious discrimination. Religious gatherings were grouped with other types of gatherings based on proximity and length of time of exposure. In its effort to provide preferential treatment for only religious gatherings, the majority even ignored science. California provided experts showing how shopping for groceries differed from worship services in the amount of droplets to which someone would be exposed. In Fulton versus City of Philadelphia, Philadelphia found that some of its foster care providers would not license same-sex couples to be foster parents. The city ceased referring children to these agencies, including Catholic Social Services. The Catholic group sued the city, arguing that it has a constitutional free exercise of religion right to refuse to allow same-sex couples to become foster parents because of the church's opposition to same-sex relationships. The Catholic group got the court to agree that any religious organization has a special right to be exempt from a branch of government's otherwise universally applicable law prohibiting the city from funding discriminatory foster care and adoption programs. This is a very egregious instance of demanding and actually obtaining an unconstitutional special privilege for only religion. A government-funded program should not assist those organizations and individuals involved placing children in foster care who would reject potential foster parents just because they are an LGBTQ couple. We suffered more serious losses and setbacks last year. In Kennedy versus Bremerton School District, a high school football coach conducted actual prayer sessions with his team and the opposing team on the football field after games. Large numbers of spectators would come down and participate in these prayers. The coach refused to stop holding these prayer gatherings and was suspended by the school district. He sued, and the religious right supermajority ruled in his favor, but they could do so only by grossly distorting the actual facts of the case. Justice Gorsuch's majority opinion asserted that the coach offered his prayers quietly while his students were otherwise occupied, and that he made short, private, personal prayers. Gorsuch wrote that there is no indication in the record that anyone expressed any coercion concerns to the district about the quiet post-game prayers that the coach asked to continue and that led to his suspension. Gorsuch misstated the facts to assert that unlike prior cases where the court ruled that prayer at public school events was unconstitutional, that this coach's prayers were not publicly broadcast or recited to a captive audience, and students were not required or expected to participate. In fact, a 16-year-old atheist player said that he felt compelled to participate in the prayer out of fear that he would be given less playing time if he didn't participate. In dissent, Justice Sotomayor took the unprecedented step of attaching photos of her dissent to her dissenting opinion, showing the truth about how the coach was conducting these large-scale prayer meetings on the field with both teams and how spectators stormed the field to participate. She even showed how the police had to admonish parents to stay off the field as these post-game prayer gatherings were so large. Never before has a justice attached evidence to a dissenting opinion in order to refute the erroneous factual claims of the prevailing majority. She also reminded the court that it had always held prayers led by any school official to be unconstitutional. The court, unfortunately, in this case, also abandoned what we used to call the Lemon versus Kurtzman test. This was a useful method of determining if a law or any government activity violated the constitutional privilege against the establishment of religion, known as the Establishment Clause. Under this three-part test, the court required all government actions to have a secular purpose. Government could not do anything that would have a primary effect of advancing or inhibiting religion. There could be no excessive government entanglement with religion. Instead, the court now looks at, instead of these three guardian factors which were so important to keep government from promoting religion, the court is now merely looking to references to historical practices and understandings. This is dangerous. It means that past benighted and ignorant practices will prevail over what the Constitution was designed to guarantee, as long as such defective practices were part of our nation's tradition. Here's an example. The Sedition Act of 1789 was in force while the First Amendment was being developed. And for 10 years after its ratification, even though it was clearly unconstitutional, it made it a crime for anyone to print, utter, or publish any false, scandalous, and malicious writing about the government. It was used to prosecute and convict people for insulting President John Adams. If we used the court's new historical practices approach, such a law would be upheld today, even though it clearly violates the free speech clause. Now we come to a most somber and serious destruction of a major freedom that existed in our nation for virtually 50 years. Dobbs versus Jackson Women's Health Organization. We all knew this day was coming, yet nothing could prepare us for the grief, health, and life-threatening state actions, deprivation of basic liberty, and prosecution as actual persecution that the reversal of Roe versus Wade in June of last year has already inflicted on the United States. The Due Process Clause of the 14th Amendment has been held to guarantee some rights that are not explicitly set forth in the Constitution. Alito, in his majority opinion, wrote that such rights must be deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Again, this type of position is extremely dangerous. History and tradition are filled with flouting many guarantees that the Constitution provides. The Constitution's actual meaning, not historical traditions that misinterpreted it, should always prevail. If just being deeply rooted in history is the standard, this could nullify the right to use any form of contraception and repeal all the progress made on LGBTQ rights. Alito wrote that a claimed right to abortion was different from other privacy rights. He said that what sharply distinguishes abortion from other rights the court has recognized in the past is that abortion destroys potential life, and that the law at issue in this case regards the life of the unborn as a human being. But Alito's majority opinion never presented any scientific argument for the claim that embryonic and fetal personhood exists throughout pregnancy. The majority opinion also ignored Roe's nuanced treatment of the stages of pregnancy. The majority merely asserted, without proof, that the preservation of what it calls prenatal life at all stages of development allows the residents of each state to regulate or entirely prohibit abortion. Alito wrote that Roe arrogated this authority by removing the decision-making process from majority rule, and that the court is now properly restoring that authority to the people and their elected representatives. Now, this majority opinion never explained how it is that the Constitution fails to offer a woman protection for a process unfolding entirely within her body, but allows the state to take control of her private bodily functions. Roberts, the chief, would not have overruled Roe, though he had always wanted to in the past. He would have upheld Mississippi's 15-week limit, but he would not have gone any further. He said that a 15-week limit extended far enough to ensure reasonable opportunity to choose. He then wrote that the court's decision to overrule Roe is a serious jolt to the legal system, regardless of how one views the Roe versus Wade decision. He said a narrower decision would be markedly less unsettling, and nothing more is needed to decide the case currently before the court. What Roberts is really saying here is that he doesn't want history to reflect how brazenly the court made purely political decisions during his tenure as Chief Justice. It seems his real concern is that the majority's opinion will be a jolt to his legacy. Now, Breyer, Sotomayor, and Kagan dissented. They wrote, respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over the most personal and consequential of all life decisions. For in this nation, the dissenters wrote, we do not believe that a government controlling all private choices is compatible with a free people. The dissent also predicted what we have been seeing since June of last year. States are attempting to impose the most severe penalties on both physicians and even women who have an abortion. 10-year-olds who are raped and impregnated by a family member can no longer obtain a safe abortion in many states. On the issue of abortion alone, we are not the same country we were just 1 year ago. The most recent example of the horrendous trauma that is being inflicted on our nation since Roe was overturned was last month when a religious right-wing Trump-appointed federal judge in Texas ruled that the abortion drug mifepristone, used in 54% of all abortions performed in the United States, was never sufficiently vetted for safety concerns by the Food and Drug Administration, even though this medication has been safely used for 23 years. The case of Alliance for Hippocratic Medicine versus FDA was then appealed to the religious right-wing dominated Fifth Circuit Federal Court of Appeals that covers Texas, Louisiana, and Mississippi. The Fifth Circuit agreed to keep the drug on the market, but with additional restrictions such as only being available for use in the first 7 weeks of pregnancy and requiring the drug to be dispensed in person by a physician, upholding the lower court's ban on its being mailed. The restrictions also revoked the 2019 approval of the generic form of this drug. The Supreme Court ruled 7-2 that the pill could be in use as it was prior to the ruling by the district court judge until the appellate process unfolds. The Fifth Circuit will hear full oral argument on May 17th, this month. Whatever it decides, the Supreme Court will be asked to take the case. It doesn't have to, but it almost certainly will. Once the case is fully before the Supreme Court, as opposed to just being brought up for temporary and emergency stays, we can't be certain how the court will decide the case. It's keeping the status quo intact until it takes up the matter on a full appeal is no indication of what ultimate decision will be rendered by the Supreme Court regarding the abortion bill. Now, Kavanaugh, in voting to overturn Roe, emphasized in his concurring opinion that the entire question of abortion should be left to each state's government. If he is consistent, this would mean that he would strike down any kind of nationwide ban on anything to do with abortion, because that would preempt each state from making a determination for itself. Having to trust Justice Brett Kavanaugh to be consistent shows how desperate our plight is right now, this moment, in trying to stave off the ever-expanding religious right-wing tyranny that we're facing. In Groff versus Postmaster General, now before the court. A Christian postal worker wanted Sundays off in order to observe his Sabbath. He insisted that co-workers who don't have religious reasons for not wanting to work on Sundays must cover for him, even if those other co-workers lose weekend time with friends, family, and recreation. He insisted that all other reasons for not wanting to work on Sunday must be subordinate to his religious reasons. We won in the trial court and the Court of Appeals. It's a bad sign that the Supreme Court took this case. The justices could have just let the Court of Appeals decision stand. If we lose, the result will be cataclysmic. It will mean the court will have conferred a special right for only the religious to force co-workers to cover for them on days that such religious employees insist they can't work because of religious reasons. Even if that means that non-religious workers and those with different religions must miss weekend days of rest and recreation that everyone else gets to enjoy. Now, it seems that a commitment to imposing a theocracy on the nation also involves ignoring science generally. This is part of an overall scheme to erode reliance on empirical evidence in formulating laws and public policy. In June of last year, the court issued a 6-3 ruling that brazenly ignored the scientific evidence for how climate change threatens the nation and the world. With no actual constitutional basis, the majority deprived the Environmental Protection Agency of the power granted to it by Congress to curtail greenhouse gas emissions. This preposterous decision was fabricated for no reason other than political support for the business interests of power plant operators and the states in which they are located. West Virginia versus EPA, the court majority voted to strike down regulations that Congress clearly empowered the EPA to promulgate under the Clean Air Act. These regulations authorized regulating power plants that emit greenhouse gases which severely aggravate climate change. Now, just a week before, the court majority obliterated almost 50 years of protecting abortion rights under the Constitution. A rationale used by the court, as we just saw, was that the term abortion appears nowhere in the Constitution. Yet, in the EPA case, the court majority invented out of nowhere something called the Major Questions Doctrine in order to have an excuse to invalidate the powers to regulate greenhouse gases that Congress conferred on the EPA. Supposedly, under this Major Questions Doctrine, which no one has ever heard of before, Congress has to be even more specific than it was if it wants to authorize the EPA to regulate such power plants. There is no basis in the Constitution for such a requirement. Under the Federal Supremacy Clause of the Constitution, such congressional delegation of power to a specialized agency with expert knowledge in a given area is clearly a constitutionally permissible function that Congress can perform. Now, dissenting, Justice Kagan wrote, "Today, the court strips the Environmental Protection Agency of the power Congress gave it to respond to the most pressing environmental challenge of our time." She concluded her dissent by saying, "The stakes are high, yet the court today prevents congressionally authorized agency action to curb power plants' carbon dioxide emissions." And then she laments, "This court appoints itself, instead of Congress or the expert agency, as the decision maker on climate policy." And then Justice Kagan finishes by saying, "I cannot think of many things more frightening." Well, of course, we certainly join Justice Kagan in being frightened. The only way to make sure that church-state separationist justices are confirmed to the court and that religious right-wing nominees are defeated is to treat every presidential election and every U.S. Senate election as a referendum on the court. Above all else, we must try to make sure that we have a president who opposes the religious right and that we have a majority of senators who will not confirm religious right-wing nominees to any federal court, but would confirm pro-church-state separation nominees to all federal courts. Now, we must address the currently looming greatest threat to the Constitution we have ever confronted in our lifetimes. Like a torpedo that travels underwater, frequently undetected until it strikes its target, the religious right has been persuading states to pass resolutions calling for the first nationwide constitutional convention since 1787. At such a convention, the entire Constitution in its present form can be eliminated. Any amendment can be passed. A completely new Constitution can be produced. In order for such a constitutional convention to take place, all houses of 34 state legislatures must vote for it. A convention call that passes in this way cannot be vetoed by a state's governor. Today, 19, up to this present moment, 19 state legislatures have passed a resolution calling for such a convention. In 7 other states, at least one house of the legislature has passed it. The 19 states that have fully voted to call a new constitutional convention to completely revise the United States Constitution are Georgia, Alaska, Florida, Alabama, Tennessee, Indiana, Oklahoma, Louisiana, Arizona, North Dakota, Texas, Missouri, Utah, Mississippi, Wisconsin, Nebraska, West Virginia, and South Carolina. The 7 states in which at least one house of the legislature has voted for it are New Mexico, Iowa, South Dakota, Virginia, North Carolina, New Hampshire, and Wyoming. Whatever proposed changes or whatever entirely new constitution emerges from the convention would require ratification by all houses of 38 state legislatures. That's only 4 more than required for the convention to take place in the first place. There's something we can't risk under any circumstances, and that is allowing essentially the religious right to be permitted legally to revise the entire United States Constitution. There can be nothing off limits to fighting this. All of us must contact state legislative representatives or in people, friends, relatives that we know in other states and tell them to tell their legislatures to oppose such a resolution. If one house of a legislature has already passed it, people living in the various states must contact members of the other house in order to dissuade them from also passing it. Now, in those states where the convention call has passed both houses of the legislature, people in those states have to try to get the legislature to reconsider its vote, even though it's not yet settled constitutional law if a legislature can reverse an earlier vote to approve. We're in uncharted territory. We've never been in this situation before. One of the main people pushing for this new constitutional convention is the religious right-wing Prince of Darkness, Steve Bannon. Such a convention could easily result in an entirely new constitution that could declare the United States to be officially a Christian nation. It could revoke the civil rights of non-believers. It could eliminate free expression. Even the religious right-wing Supreme Court Justice, the late Antonin Scalia, warned against a new constitutional convention, as did Nixon-appointed Chief Justice Warren Burger. They correctly admonished that such a process would be too open-ended and could result in virtually anything. We have to be willing to work with anyone who shares our views about the importance of equality before the law for both believers and non-believers. Somehow, as difficult as it is, even if we don't ultimately win, and even if most of us here this evening may not live to see the results of our efforts in once again securing the separation of church and state, we have to do whatever we can to try to stop America's headlong march toward religious totalitarianism. No branch of government should ever be permitted to favor those who believe in the supernatural over those who don't. We are in danger of legally enforceable tiered levels of being an American, with officially conferred greater liberty for those who harbor religious beliefs versus those who reject such beliefs. We are in a life and death struggle to preserve the very core of modern civilization in the United States. Thank you.
What is religious exercise? Decades ago, there had to be an actual religion and doctrine, and the courts gradually stopped making judgments and allowed the assertion of religious beliefs, and it then became ethical and moral belief against, for example, serving LGBTQ weddings with cake, masterpiece cake shop and all. So it seems that this idea that any ethical, moral, or even, no, I don't want to do it, thought has taken the place of religious expression. Where do we stand now, and where are we going with that?
It's exactly as you said, Jonathan, exactly as you said. The court, particularly Justice Kavanaugh, emphasizes that we cannot examine the nature of a person's religious claims or its sincerity. We have to take it at face value. Here's an example. In the Hobby Lobby case, the Supreme Court said, and we lost 5-4 in 2014, the Supreme Court said that religious employers, even of secular companies, if they're personally religious, don't have to comply with the Affordable Care Act's mandate to provide contraception insurance coverage for their employees, because they said that all the employer has to do was to notify the government or the insurance company that they're not providing the insurance coverage for contraception, and the government will see to it that someone else supplies the coverage. Well, in the Little Sisters of the Poor case, a group of nuns said that even giving this notice violates their religious beliefs because they are participating in a process that will eventually result in their employees getting coverage for contraception. So the court let them even avoid the giving of notice. So it's exactly as Jonathan has phrased it. The court is now allowing anyone to assert any religious belief without examining its validity or its sincerity in order to avoid complying with the law that is binding on the rest of us. This is very, very dangerous, and the court has not yet articulated what the limits are of how this could be used.
A lot of these religious cases, cases that have been recently decided, very similar ones were brought previously, but they're brought under the Equal Protection Clause of the 14th Amendment. In other words, by this law, you're preventing me from practicing my religion like I wanted, so I'm not getting the equal protection that other people are. That's now changed, and it's freedom of religion. They're bringing it under the First Amendment. Well, my first question would be, do you think that would have made any difference? Personally, I don't, but do you think that would have made any difference to the Supreme Court if people had continued to use the 14th Amendment? And the other question, the second question, and it sounds like a joke, but I'm not really joking. I know that the court will have to reverse Hobby Lobby if that's ever to be reversed. But the president of Hobby Lobby, David Green, former president, he was a closely held company. It has to be a closely held company, which means a family-owned company. It has to be a religious person. He's got to be opposed to birth control. He's got 3 kids. Why didn't somebody depose him and find out how he only had 3 kids if he's opposed to birth control? I mean, it doesn't make any sense.
Well, first of all, with respect to your 14th Amendment question, you've raised a very profound issue of constitutional law. But you also gave the right answer, that to this Supreme Court, it would have come out the same way. And the reason is this. The Supreme Court will say that the 14th Amendment incorporates the free exercise of religion, though Thomas and Gorsuch says it doesn't incorporate the Establishment Clause, some crazy, twisted reasoning, but that because of equal protection and the special rights of the religious, that it comes out the same way. So whether you say free exercise of religion or equal protection, that in fact, equal protection means unequal protection for the non-believer, but more than equal protection for the believer, because the believer has special rights. So if, for instance, and again, you raise a very profound question of constitutional law. If, for instance, the Equal Protection Clause is held up as saying everybody has to be treated equal, but the court says, no, the Free Exercise Clause, which protects only religious believers, requires special privileging for the religion. If push comes to shove, the court would probably elevate the Free Exercise Clause above the 14th Amendment, the free exercise, the Equal Protection Clause, and they'd use some kind of twisted reasoning. Now, as far as your question about the owner of Hobby Lobby, see, what you are touching on is the new Brett Kavanaugh doctrine that, and the Alito doctrine, that we take at face value your profession of religion. So we don't yet know how this would play out. Let's say the owner of a restaurant that does business with the general public says, my religion seriously admonishes me not to do business with atheists. I'm not going to serve the atheist banker at my lunch counter and I'll just turn them away. Well, that evokes some pretty scary memories. We don't know what the court would do with that. But you see, the issue you raise is, let's say that Green had no kids. The court wouldn't say, okay, do you personally practice birth control? He could come up and say, my religion specifically says that I can have birth control, but I can't provide insurance coverage for my employees, and that's my honest religious belief. And the court would say, okay, we can't question that. They're very good questions. Thank you.
Does it matter that the majority of the American people have the lowest, hold the court in the lowest esteem, probably almost historically? And number 3, and this is what one of our guests is going to cover later in this summer, Erwin Chemerinsky, is that the originalists on the court tend to be cherry picking what's convenient for them to follow in terms of originalism or not originalism. They just kind of decide what they want to cover. But after you talked about the new convention to reestablish or recreate our Constitution, nothing else seems to matter now. It seems like that's what we have to have a laser focus on making sure this never happens. I keep thinking, if we have a Christian nationalist country, it gives the okay for every other Muslim, whatever kind of religion you want to dominate their own countries and economies, so that there be no, why have democracy if you can have a Christian nation in the biggest, one of the biggest and most successful democracies in the world? You know, why can't everybody else then have their own religious, tyranny?
Well, you see, the thing is, you're right about the court's unpopularity and losing the trust of more people than ever in history. You're absolutely right about that. But it cuts all ways. The court is not supposed to respond to popular opinion one way or the other. So that is a very important issue. Now, as far as the originalists are concerned, you're right, they are cherry picking, because in no other area of constitutional law is the original intent of the framers more clear than in the Establishment Clause, of which Madison was the primary author, where he said frequently, both before and after drafting what became the First Amendment, that non-believers have to be equally protected. Madison didn't even want religious institutions to hold property, and he openly opposed chaplains in both Congress and the military. So if we take the original intent of those who drafted and had the major input into the First Amendment, originalism would require the separation of church and state. And so as far as the Constitutional Convention is concerned, I only found out about this myself a few months ago. I've mentioned it in a few places around the country. It's happening. It's hard to get people to even believe it's happening. I feel like William Shatner in the old Twilight Zone, where I'm the only one who sees the gremlin tinkering with the plane engine, and then they put me in the straitjacket, but it really happened. I mean, but it is happening, and so the only solution is to contact people we know in these other states and get them to contact their state legislators. Remember, in so many states, state legislatures are part-time, sort of the people's kind of body that even though they make laws for the state, they're part-time, they have no actual legal experience, but they fall all over themselves to see who is the most pious. These people, if it reaches 34, can convene the new convention. So we have to contact everyone we know in these other states and have them bring as many people as possible to the task of trying to stop it or to reverse it. But it's absolutely imperative. And so you're right, this comes before anything, and somehow we have to galvanize fair-minded people, religious, non-religious. Everybody who cares about the freedom of their neighbor needs to stop this. Yes.
But I also want to thank our speaker. He's really given us a lot of thought. Here's my question. I'm going to ask if you could possibly predict how the Supreme Court might rule in the following situation. So I read an article in the American Prospect about various Republican legislature-induced changes at the state level. And there's a section about Mississippi. And I was very surprised to read that Mississippi actually has one of the highest vaccination rates in the United States and extremely healthy children. And this is because they have for 30 or 40 years had a law which requires that every child who attends public school must be vaccinated for the usual which is a lot less than when we were kids, right? And certainly includes important things like polio. Well, evidently, there's a religious group that has decided that it is contrary to their religion, whether it may actually be or not is irrelevant, that it undermines the freedom of some to be able to keep their child free of this pollution of vaccination. And believe it or not, the governor is about to sign a rule which is going to make it optional. If you have a religious or even what they call a personal objection, you do not have to have your child vaccinated, and he can still or she can still go to public school. So you can see where this is heading. Now, when I first thought about it, I said, well, if this goes to the Supreme Court, it's kind of like the COVID stuff, because the court already ruled that people, can gather even if they're infected and nothing to do with vaccination, and that we don't have to worry about the possibility that people will infect one another in a large gathering. But as I thought about it more, it seemed to me that this business about vaccination is much further reaching, because in the COVID and the religious institution case, people are electing to go to a church or a synagogue or whatever where they know the people are going to be unmasked and they're going to be singing and so forth, and they're taking that risk on kind of by choice. But when you send your child to public school, it's really not the same. Now you're essentially endangering the entire population. And I'm just wondering, how far do you think the Supreme Court will go? Would they uphold the right of the religious to foist upon us a condition under which the entire population is at risk of major disease?
We have a partial and weird answer already. A group of Navy SEALs sued President Biden, saying that because of their religious convictions, they don't want to be vaccinated, even if it means infecting their comrades. The federal district court in Texas, could be the same guy did the abortion pill ruling, I don't know, or a close colleague of his, decided that the Navy SEALs have a free exercise of religion right to not get the vaccine, even if it means they might infect others. Well, the Fifth Circuit Court of Appeal upheld it. The U.S. Supreme Court gave us a bit of a reprieve, but the way they did it was a little bit strange. What they said was that these special forces operatives do have a free exercise right of religion not to take the vaccine, but the Navy and other branches of the armed forces will then have a right to keep them away from others in the fighting forces so they don't affect anybody. That's the most we have so far. Before we close this meeting, I do want to thank Sue for putting this together. And I also, I don't want to be the only constitutional lawyer that gets the spotlight tonight. The man who introduced me, Jonathan Adler, has had a stellar career in which he single-handedly argued cases that protected the constitutional rights of minorities, that brought about fairness in the justice system overall. So you have among you living here also a very accomplished constitutional lawyer who did a lot of good work for our society, and that would be Jonathan Adler. Thank you.